Welcome to This Week in Education Law, School Administrator's Guide, episode number 7. Each week, I share up-to-date court decisions on education law. I pay special attention to the court decisions and arguments related to school administrators' daily work. Today, I focus on a case about potential race and age discrimination in employee layoff and hiring. Here is the question. What evidence is needed to make a strong case of race and age discrimination claim? Chapman was an African American working as a school library assistant at a high school in the Chicago Public Schools from 1997 to 2009. In August 2009, the Board of Education informed her that her position was eliminated and she was laid off at the age of 62. Chapman later learned that although the board claimed the position had been eliminated, the board had hired a younger, non-African American employee in the same role. Chapman filed a charge of discrimination with the Illinois Department of Human Rights and the Equal Employment Opportunity Commission, and then sued in the Illinois State Court. The school board settled with Chapman in 2015. In addition to a monetary payment, the district would arrange for interviews for open positions for which Chapman was qualified. Chapman interviewed for positions at 5 different schools, but did not receive any job offer. The first interview was for a library assistant position at Beasley Academic Center in June 2015. On September 9, 2015, Chapman learned that the position was filled with another candidate. The second interview was for a teacher's assistant position at an elementary school. There was a dispute about the interview. The school board denied that there was an open teacher's assistant position at the school. There was email evidence suggesting that a board's talent office employee communicated with Chapman's counsel on September 10th, which was the same day of Chapman's claimed interview date. But in the email, the board's talent office employee wrote to Chapman's counsel, the principal of the school will be contacting Ms. Chapman for an interview. Please let me know if she doesn't hear from him for some reason. The third interview took place in November 2015. Chapman had an interview with the school principal for a library assistant position. She was not hired for that position. The school district claimed that the position was eliminated for budgetary reasons in February 2016, but the board later disclosed that the school principal had extended an offer to another candidate who was under the age of 40 to fill the same position around November 30, 2015. The fourth interview was with the school principal for 2 open special education classroom assistant positions on December 2, 2015. Chapman was not hired. Instead, the school district hired an African American man who was under 40 years old and an African American woman who was over 40 years old. In an affidavit, the school principal explained that the younger African American man hired for one of the positions was the school's graduate who had volunteered at the school and worked with the specific special education student whom the special education classroom assistant would assist. The fifth and the final interview was with a school principal for 3 open special education classroom assistant positions on December 17, 2015. Again, Chapman was not hired. Instead, the school board hired 2 African American women over the age of 40 and a non-African American woman under the age of 40. At the time of her interview, the non-African American woman under the age of 40 did not have the requisite paraprofessional license to fill the special education classroom assistant position. By the time she started in the position, however, she had obtained the license. Chatman filed another charge with the Equal Employment Opportunity Commission, alleging violations of Title VII's anti-discrimination and anti-retaliation provisions, as well as a violation of the anti-discrimination provision of the Age Discrimination in Employment Act. The district court ruled in favor of the school district. Chatman appealed. The Seventh Circuit affirmed the district court's conclusion, ruling in favor of the school district. Both the 14th Amendment and Title VII of Civil Rights Act of 1964 prohibit employment discrimination based on race. The 14th Amendment and Age Discrimination in Employment Act prohibit employment discrimination based on age. To prevail in courts, employees need to provide enough evidence to establish, first, they were a member of a protected class. Second, they applied for and was qualified for the position. Third, they were rejected for the position. And fourth, the employer hired someone outside the protected group who was not better qualified. A protected class is commonly defined as a group of people who are provided special protection. It focuses on groups of people historically discriminated against and denied opportunities in the workplace, marginalized by society, or considered to represent a minor segment of the overall population. The legal concept of a protected class seeks to provide a voice for those whose voice faces suppression historically, systematically, and currently. The federally protected classes include race, religion, national origin, age, those over 40 years old, disability, sex, pregnancy, familial status, and military or veteran. Faced with the evidence, an employer can defend a failure to hire decision by providing a legitimate, non-discriminatory reason for the adverse employment action. One example is hiring someone who were better candidates because of qualifications and experience. If an employer can provide a legitimate, non-discriminatory reason, then employees need to provide further evidence to establish that the employer's reason is a pretext for discrimination. Here, pretext means a lie, specifically a phony reason. For example, in my earlier video on canceling a job posting to avoid hiring a candidate of disfavored class, for example, by gender, race, and age, the Sixth Circuit concluded that University of Cincinnati not only failed to hire a job candidate because of his gender, but then they added the insult by canceling the position as a pretext to conceal the discriminatory reason for the failure to hire. In this case, Chatman could not provide evidence to establish that she was better qualified than the candidates hired, and the school district provided legitimate, non-discriminatory reason for hiring other candidates. Budget cuts were a legitimate, non-discriminatory reason. The candidate was offered the job, never started the position because of the budget cut. So the budget cut was not a pretext for failure to hire. Also, the school district selected other candidates who had more hands-on experience relevant to the position or had the state paraprofessional license. Those are legitimate, non-discriminatory reasons offered by the school district to explain their hiring decisions. There was no evidence to suggest that those reasons were a lie or a phony reason to conceal discrimination. Chatman also claimed that she was not hired because the school district retaliated against her because of her previous discrimination charge against the school district. If you were Chapman, you need to prove a causal connection between your previous discrimination charge and the school board refusing to hire you. How to prove it? You need to provide evidence to show that the unlawful retaliation would not have occurred in the absence of the alleged wrongful action or actions of the employer. In this case, the two school principals who hired other candidates wrote in their affidavits that they were not aware of Chapman's previous discrimination charge at the moment of making their hiring decisions. And Chapman had no evidence to prove that the principals had lied. The Seventh Circuit concluded that those principals' decision not to hire Chapman were not retaliatory. How does this case help you with your work as a school administrator? Faced with employees' discrimination claim, you must be able to defend your decision by providing legitimate, non-discriminatory reasons. You also need to provide compelling evidence to support your defense. On the other hand, if you believe you've been discriminated by your employer, it is important to document and save evidence to prove your case. Without strong evidence, even the best attorney won't be able to help you in court because you may not have a case. In my future videos, I'll share how to save evidence for employment-related lawsuits in the right way. I hope the case introduced today is helpful for your hiring practices. I'll see you next week in This Week in Education Law, School Administrator's Guide.